Hello and welcome to the Imprint Weekly Podcast. I'm John Kelly, Senior Editor of the Imprint, a daily news site covering child welfare and youth justice around the country. You can read all of our coverage at imprintnews.org or check us out on Facebook or Twitter at the Imprint News. You can also sign up on our homepage for our free weekly and monthly newsletters. And for professionals in child welfare and youth justice, subscribe to our Youth Services Insider section for a closer look at news on business, policy, and practice. The Imprint Weekly Podcast is also a member of the SafeCamp Audio Network. Check out our show page and all of SafeCamp's other great podcasts at safecampaudio.org on the web or SafeCamp Audio on all social media. So on today's episode, we're going to keep the Rule-a-Palooza episodes coming. This is our third installment. As I have explained early in each one of these episodes, we've discussed a few times on the show the fact that the Biden administration has been pretty active in terms of making new rules and regulations in the child welfare space. I wanted to put these together so that listeners could have kind of a 101 of sorts, featuring subject matter experts so they can really just understand the nuts and bolts of how each one of these rules works. So today we are talking to Currey Cook, Director of the Youth and Out-of-Home Care Project for Lambda Legal, about a new rule that is meant to ensure that states are maintaining a stable of foster homes and other foster care options that proactively identify themselves under a new term of art here called designated placements that will support LGBTQ youth in foster care. So without further ado, here is our third Rule-a-Palooza. This is Currey Cook talking with us about designated placements for LGBTQ plus youth. All right, we are doing a series of guest interviews on all the new Biden administration rules that have come out or might come out soon. And today we have Currey Cook, Director of the Youth and Out-of-Home Care Project for Lambda Legal, to help us break down a new rule aimed at ensuring safe places are available for LGBTQI plus youth who are in foster care. Currey, thanks for joining us on the Imprint Weekly Podcast.
Hi, thank you for having me. Hi, everyone. Currey Cook. I use he, him pronouns. And as John said, I'm Senior Counsel and Director of the Youth and Out-of-Home Care Project at Lambda Legal and based out of our New York office.
And now he's going to have to tell you even more about himself because house rules here. Currey's going to have to give you a favorite in one of these categories, at least one. You can give us more, Currey, if you want, but here they are. TV, show or movie, book, musical group, or sports team. Currey Cook, what do you have for the people?
I'll do TV show, and one of my favorites of all time for sure is Mad Men. And if I can sneak one more in, Watchmen on HBO is also one of my.
So funny you say that. I had like a bunch of time on a flight yesterday, and I was making a list of all the shows. I just was like, oh, I can't wait when it came out. And then just for whatever reason, it blew by and I didn't watch it. And that was like one of the ones on there. Mad Men's definitely one of the best ever. So good choices, both. Okay, so this rule is entitled, I think Currey probably has the hardest job of any of the people I'm bringing on for Rule-a-Palooza this summer, because this one's pretty complicated. The rule is entitled Designated Placement Requirements under Titles 4E and 4B for LGBTQI plus children, just shattering the record for letters involved in one rule. And of course, I will include a link to the rule and to some of our coverage in the imprint about this for people that really want to wonk out and get into the details. But today, Currey is here to help us just get you a basic understanding of this action. So with all of that said, let's start with the kind of first order question, Currey. What is the problem or set of problems that this rule seeks to solve? What was the status quo beforehand that this sort of injects itself into?
Yes, the title just rolls right off the tongue,
as they often do.
And folks may also be a bit confused because the notice of proposed rulemaking for this actually had a different name. Right. The Safe and Appropriate Foster Care Rule was the original notice of proposed rulemaking, or NPRM. So in addition to changing some things from the way they first proposed them, they also ended up changing the name. Right. So just so folks are clear that it's actually the same subject matter at hand, they just tweaked the title. So yeah, the issue or problem that this seeks to solve is a long-standing one. And that is, we know from a bunch of studies and just a mountain of individual anecdotal information to anyone working in the child welfare system in any capacity that LGBTQ plus youth are overrepresented in the system compared to their presence in the general population. And there have been a couple of recent studies that probably listeners are familiar with, one from Cuyahoga County in Ohio and one from New York, that showed a 30 to 34% of the youth they surveyed who are in care identify as LGBTQ plus. Estimates in the general population range between 12 to 15%, probably maybe a little bit higher for younger folks now. But so that's one issue. Like, by those studies account, almost a third of youth in care LGBTQ plus. We also know from some of those studies and qualitative information that LGBTQ young people in care have higher rates of placement in congregate care. They have higher rates of experiencing homelessness while in care, and when exiting care, they uniformly report having more challenges around harassment, harm, discrimination based on who they are while in care than non-LGBTQ plus youth. Also, of course, family rejection based on identity isn't the only reason for a lot of LGBTQ youth being in care, but it's certainly a driver of the overrepresentation in care. So all of those things, I think, were sort of the impetus for focusing on this particular population with a rule. Also at play is the fact that federal child welfare statutes don't contain a non-discrimination clause within them explicitly that includes sex, sexual orientation, or gender identity as a protected class. So even though young people in care have constitutional rights to freedom of expression, equal protection, due process, all the same that we all do, and even more so when placed out of home care and in government custody, those sorts of things aren't necessarily top of mind to caseworkers and agencies on a daily basis. And without something like explicit and clear in federal law, this has not been a requirement that states feel like they're under an obligation to address necessarily, although a lot of states have. So it's also something I think that's meant to have some uniformity across the country of what the basic obligation expectation of states are to LGBTQ plus youth in their care.
Yeah. So really to crystallize it, I would say, if you were just trying to get the what is the problem down to one line of that was a really good explanation. It's we have a growing understanding that there is a very high percentage of youth who are in foster care, particularly older ones, who identify as LGBTQ plus. And while there are plenty of really supportive foster parents out there, there has never been any sort of just across the board 50 state statement of fact, you must have those. You must have those kind of placements, right? We have not had that.
Yeah. I mean, the super basic issue is in LGBTQ plus youth deserve to be treated equitably and with dignity and respect, just like any other young person, period. But especially if you're placed in foster care and have been removed supposedly because you were facing harm, that you shouldn't then face harm once you're in care.
Okay, so that is the problem. Now let's, in as layman's terms as we can, what specific things are changed or established by this rule that we just kind of set up?
Yeah, I think it's important to note that this rule is providing some additional information and clarity and specificity about what states' obligations are to LGBTQ plus youth. It's not changing or establishing that LGBTQ have a right to safe and proper care. It's every young person in care has, but it's kind of adding additional specificity about what that should look like and what states' obligations are. And in that sense, it is changing from what the status quo was before, because there wasn't that. There wasn't that specificity. There wasn't that guidance in federal regulation. ACF has put out both back in 2011 and then in 2022 a really good information memoranda about what states should be doing to support LGBTQ plus youth. But that is, of course, more guidance rather than the law, right?
Right.
So what the rule establishes is some clarity to say that the requirement for safe and appropriate foster care applies to all youth, including LGBTQ plus youth. They don't somehow have an asterisk beside them. They also are entitled to that. And saying that that means that you have placements that are free from harassment, mistreatment, or harm, and defining what they mean by harassment. So really more specificity than has existed in federal regulation before about like what we mean by safe and proper care in this context for them. So that's new. The other thing that's new is that it is requiring that states have a sufficient number of designated placements that LGBTQ youth can request, or if someone thinks they would benefit from one, they can make sure that they're in one. And this is a term of art that someone created that now exists and carries with it a few requirements of what a designated placement should have or should be. And that includes like certain training requirements. They're supportive of LGBTQ young person's identity. They're connecting them with resources. So there's some there if they're saying there are designated placements required.
Yeah, like I was trying to think as I read through it, like what is the best way? Because you're eventually gonna have to train caseworkers on sort of explaining to resource parents like what does it mean to be one. My read of it is like you have to be not just tolerant but supportive of a young person's choices when it comes to orientation and identity. And not only that, but you need to as proactive as the youth wants you to be in helping them connect to a community or to connect to, safe activities or whatever, you have to be willing to do that. Like at home, you got to be supportive. And if they want to join a club or they want to be out there, in a different way, like than just being at home, you got to help them do that.
I agree. I think that is one piece of the rule that I have some concern about, because I think that this rule doesn't go nearly as far enough as it should have. And also some of these criteria that the agency has now said must exist if you have this categorization of designated placement are things that like all agencies and all providers should be doing for LGBTQ youth as a basic part of like good casework and like
Right.
supporting young people. I mean, all the social science, all the information from any entity that opines about what's good for kids is quite clear. Like affirmation of identity, connection to supportive community resources improves well-being. And that's one of the core tenets of the child welfare system. So I think it's a little odd that we are saying that only certain providers should be doing these things rather than having a basic expectation that all providers are doing this for all youth, including LGBTQ plus youth. But
you think that part, I mean, without, I'd be interested in what you would want them to do past that too. But don't you feel like part of that is because in some of these states, you have almost the countervailing thing where states have given a implicit right to some of their faith-based providers to allow foster parents to not take that view. So it's like, well, at the very least, we need to make sure that there's a counterbalancing group quantity that do,
that seems to be the approach here. To me, that whole notion flips the entire point of the child welfare system on its head. Like the child welfare system is supposed to be about serving the children in its care and not what a particular provider's needs are or aren't. I mean, I think there are a lot of providers out there who are doing this now, and a lot more who would if they had training and technical assistance provided to them. So I hope, thinking about the positive of this will this will help like move places and get them and have some states to feel like they have to start doing more to get providers, to meeting these criteria. So I think that's a good thing. I think what is concerning to me, you sort of ask about what's changed and unchanged, or, what the status quo was beforehand. I feel like, unfortunately, I think this rule just kind of it doesn't change the status quo of there being some providers out there who have refused to step up and meet the needs of the kids that they have in their care. And also, I think permitting that just kind of entrenches some of the disinformation and myths that are just rife within society about LGBTQ people. I mean, the notion that by somehow being supportive of a young person is going to like convince them to be LGBTQ, or that you somehow have like that there is anything to your attention between what your personal beliefs are around like faith and LGBTQ people versus your obligation to young people in your care. Foster parents, providers can have any sort of set of beliefs they want to have and participate in the system, but that doesn't mean that their conduct towards the youth in their care shouldn't live up to professional standards if they're in this space and receiving government contracts. Yeah. Also, I think we have, which is completely intertwined in this, we have the notion that young people in care have a right to practice a faith or not practice a faith of their own. And providers in the space, I think, understand that. And while certainly there are infringements on, I've had clients where their right to religious expression has been infringed when they're in care. It's kind of universally held that, like, okay, if I'm blank faith provider and I have a kid in my care, it's a different case. I still have to help them practice that faith, right? But then when we insert sexual orientation or gender identity or LGBTQ status into all of this, then suddenly you're not able to do that. And so, these are my concerns, that instead of trying to have providers in the space who will live up to the obligation for a third of the kids in their care, according to these studies, we have let anybody who wants to opt out.
Before I was adopted, I felt like my life was already over.
My biggest fear was that I would age out and not know how to be sufficient on my own.
At a certain age, they don't want you, you're troubled and stuff.
The clock is ticking for the more than 125,000 kids waiting to be adopted from foster care. Help the Dave Thomas Foundation for Adoption prevent them from aging out without a permanent family. Learn more at davethomasfoundation.org.
You mentioned what I think is the term within here about what this rule has to say in regards to quantity, which I think it refers to it as a sufficient number. That's complicated, right? Because I think that sort of leaves it at how many is enough. I guess the most charitable way to say it is I guess we'll find out. I guess there's gonna just be a runway with this rule where we're gonna have to figure that out. I know that your view is this is apportionment in general is the problematic concept, but within the constraints of what they did here, that's going to be, I think, interesting, because it's basically saying you have to have enough for the youth who identify this way in your care, but we're not going to tell you an actual percentage of your homes that need to be designated placements.
Yes. I mean, in our comment to the proposed rule, and I know others did in their comments because they addressed it in the final rule in their response to the comments, was, yes, this is really vague, lack of any specific guidance on what that means. And also, in particular, a concern that what does that mean if it's not based on geography or sort of very narrowed in to your community? Because you have an obligation, which we know the child welfare system often fails to meet, of keeping kids in their communities so they're close to their parent or parents for visitation, so they don't have to change schools, so they keep their community connections. And if you just have to have a certain number of designated placements out there somewhere, are they going to be near where you are? And no requirement of that, or unclear. I mean, hopefully from a common sense application of this, state agencies who are implementing the rule are going to think about that and try to address that. But, it really begs the question of how that's going to work, which I think gets you back to like the only way to have a level playing field is to have the same expectation of everybody everywhere. But it's not where we ended up.
One thing I wanted to get your thoughts on that seemed to come in at the end of this thing, but then like the second and third time I read it, I was like, is this the biggest thing in here? And I'm just going to read you this because maybe I'm over analyzing. The final rule states that attempts to undermine, suppress, change, or stigmatize a child's sexual orientation or gender identity or expression through so-called conversion therapy is a form of prohibited retaliation against any child known or perceived to have an LGBTQ plus status and or identity. Did they just ban the use of conversion therapy without any federal funds?
I think it's important that they included that because we do know that I think some folks, when they hear the term so-called conversion therapy, what comes to mind is young people being sent off to some place, like to a therapist or to a camp, or something like that. And
I'm guilty of that. That's how I think of it. I think of it.
And this unfortunately still happens, right? I mean, a number of states have outlawed conversion therapy, and those bans have been upheld by appellate courts, but a lot of states don't. So I mean, that sort of thing still occurs. But I think what happens more in foster care is like being placed, for example, in a group home where you're hearing messages that you're going to hell because you're gay, or it's sort of more like subtle pathologizing or condemning or disparaging forms of conversion therapy. I just heard of this just today on a call with an attorney for children that I was speaking to, and worked with a young person directly in a state who was sent to a therapist that the agency had not vetted and was giving that message in therapy, like with the young person. So it does happen. So I think this is significant. And I didn't really understand and was curious about their use of the term retaliation, because to me, that's sort of in response to like reporting about harm or in taking some action to address harm is the way I think about it from a common sense perspective. But the way they define it in here, and I'll just read this so I don't mess it up, is the agency must have a procedure to ensure that neither the agency nor any provider, entity, or person acting on behalf of the agency or provider retaliates against an LGBTQI plus child in foster care based on the child's actual or perceived LGBTQI status or identity, any disclosure of that status or identity by the child or a third party, or the child's request or report related to the requirements for placement or services under this part. So that to me is like you're experiencing these types of backlash or responses just by being, or by letting anybody know who you are, rather than like the third one, which is what I think of like protecting from retaliation when you report on somebody, right? For treating you bad. That to me is kind of like a common sense definition of retaliation. So I think this is significant in that it is sort of couching this as retaliation, but really it is protecting you from that response to existing as an LGBTQ person in foster care or saying to anyone that you are.
I thought that whole section, honestly, was very emblematic of how complicated this is to try and parse in the way that it is. To basically, there's an entire section in here that we won't go too deep on that basically just says, look, I mean, I think the way that they shaped this was caseworkers are supposed to be telling anybody 14 or over in foster care but without you disclosing anything to me, I want you to know that we have these designated placements that are affirming. But for younger youth, for younger children, it's more like they have to come forward, or that's what would trigger it, is if they came forward and identified, and they had to put this whole section in to basically say, like, by the way, when that happens, like, you can't retaliate against them, and you need to make sure that workers are trained on not doing that. That was a good catch by you. It did not really register to me that they were identifying that conversion therapy is retaliation. That is totally true. That is like an implied retaliation against somebody for that. Yeah.
Yeah. I mean, I think to your point, I didn't really understand why things are situated the way they are, and and using the term retaliation to include something that seems more broad to me than that. But we had suggested in our comment, as did others, that they should just have like a clear non-discrimination requirement that includes children, families, the whole system, because of course this is just about out-of-home placement, and we know, right, lots of services are provided to families like prior to removal, when you don't have an attorney appointed, you aren't in front of the court, like there aren't some of these other protections in place for you as an individual. And also you can, of course, be having a court case open but be at home with services being provided. So that to me would have been like a clearer, more expansive, comprehensive protection, and then including all examples of what that means, as they did here. But
yeah, I guess it's good that they're working through the concept of protection against retaliation, because I've talked to you about this before, but like, we're talking about this rule. They're actually, I believe, maybe you'll break some news and tell me it's not happening, but there is another thing coming down the line where likely in our annual calculation of who's in foster care, the whole adoption and foster care analysis and reporting system, or AFCARS, the states will soon be required to get at how many youth identify in different ways that are SOGI, sexual orientation and gender identity, which I think I've relayed to you. Like, that kind of freaks me out, from the concept of like, oh, so we're going to have caseworkers possibly ask a kid, maybe for the first time in their life, like, are you gay? Are you this or that? And like, what that means for youth. It's scary,
yeah, I mean, I think that's long been a concern that LGBTQ plus advocates have for a long time about, right? Like, what are people going to do with that information? And if somebody's asking that you don't have a relationship of trust with, and that you don't understand what your rights are, expectations, like, it can be really problematic. But I also think that come to a realization that the silence and invisibility that perpetuated is actually even more harmful. And that also, I think you have, like, to me, there's major generational gaps here involved, right?
Very
Like, if you had asked me when I was in high school directly, I probably would have just fainted dead away. Right. But like, that's not the world we live in. Right?
That's such a good point. Like, it's still thorny now. And frankly, I think that almost belies the other problem, which is just the data quality issue. Like, it's because you can't ask these kids to be honest. If they don't want to say it, they don't want to say it. They might say something wrong. But what you're saying is so true. Like, this is thorny. In 1985, it would have been dangerous to do this, I think,
Yes, and also, I mean, not that I don't want to imply that it can be dangerous now. I mean, we saw the state of Texas issue like a directive to investigate loving parents who were following the advice of qualified medical professionals and getting their kid healthcare that they needed. Right? We've seen the child welfare system weaponized, but so it's not as if there aren't downsides having this information, but to me, the response to that challenge is to establish clear non-discrimination protection that actually provide training and technical assistance to folks. Now, are there going to be states that resist that? Sure. But are there going to be like states that embrace and do, and we have more information and protections? Yes. So I think it's just moving, to me, the benefits of moving it forward. If we're in an era of everything needs to be evidence-based, we need to have numbers to get more resources. Well, if we don't have data, we're just never going to get there. the other thing I'll say about that is to the concern that you raise is, to me, the response, and what I talk a lot to attorneys for children about, is it's actually a conversation about your identity as a whole, right? It's about your race, your faith, or not practicing in faith, whether you may have disabilities. Like, all of these things are implicated when you're in foster care, and yet oftentimes people are just assuming what a young person's race is. They're not asking them how they identify. And also, we know children, youth of color, and families are majorly overrepresented in the system. Yet we hardly ever talk to children and families about racial discrimination and bias that they're experiencing while they're in care, because we're just not having conversations about identity as a whole. So we can't even find out what's happening right under our noses. So, I think that's the piece too. So, the answer is not to be like, okay, if your gaydar is triggered, then ask the kid about how they identify. It's like, it's like asking everybody and explaining why you're asking, because we want to make sure you're safe, and we want to make sure, you get what you need related to your identity.
All right. So what is Lambda legal? And to your knowledge, I know you coordinate with lots of other national organizations. What are you guys doing to engage states about this rule, whether it's, informing them or advising them, or how are you communicating and working on it?
Great question. We're working up a frequently asked questions document with a number of other LGBTQ words that do a lot in the child welfare space, and child advocacy organizations and others, to just kind of try to put out what the rule says in a little bit shorter, more direct form, so people can kind of at a glance understand what it does. And then eventually, I think, put out some resources for folks by kind of role in the system. So the information for attorneys for children and child advocates about how they can use the rule in their advocacy, judges, like other populations. I understand that ACF is going to be putting out some implementation guidance for states. And then they do have a bid out. I think it may have closed now, for training and technical assistance center around LGBTQ youth in the child welfare system, similar to the one that OJJP put out to establish the Pride Center for training and technical assistance. So I assume that entity, once it's like up and running, is also going to be providing guidance. So, I think the date that states have to follow the requirements of this section beginning on October 1st, 2026. So they have a while to get up to speed, even though the rule is technically effective on July 1. So I also think a bit of like our energy at Lambda Legal is going to be dedicated towards making sure that attorneys for children and child advocates know about the requirements of the rule, because to the extent that I see this making some change is having the people who were there fighting for the kids' rights and representing their express interest in court, and making recommendations to the judge about what is in a young person's best interest, so they can make sure and raise this rule with the judge in the case if their client isn't getting what they need and they aren't in a safe place, that they're saying this is what the law requires. So that's going to be a kind of focus of our efforts.
Okay. Last question. It's a big one, and I think particularly big here. So the question is, how will we know if this rule had an impact in, let's say, 5-10 years? What would we consider evidence of success? And the reason I say that that's particularly important maybe with this rule is that it seems that the monitoring of compliance with this is going to be done through the Child and Family Services review process, which is somewhat thorough in some ways, but very periodic. States go a long time between when it's their time in the box with that thing. So to get it, I'm curious for your thoughts on, like, forget the official monitoring. How, if we look back in 5 years, are we going to know, like, okay, this thing actually did something good here?
I think one thing that I would be looking to see in 5 years, well, first of all, I would hope that very soon there is a much more like comprehensive, clear, non-discrimination requirement out for children and families, whether that comes through the Every Child Deserves a Family Act, or whether it comes through like an updated and more comprehensive regulation. So I hope to see that because it's still very necessary. If it's just this, then I think I'll really be looking to see whether this has been utilized by foster youth and alumni groups, by young groups of foster young people themselves, by their attorneys and advocates to really hold systems accountable to what the law requires. And there is a requirement that states must establish a means for young people to notify them if they're experiencing harm and their placements aren't free of mistreatment, harm, and harassment. So I think if advocates are able to use this to make sure that agencies have established that they're gathering this information, that they're asking about what the results of that are, and they're using this rule in their advocacy day to day in the courtroom to ensure young people aren't harmed while they're in care and do at the very minimum have safe and proper care, then that will be a big step forward.
Currey Cook, Director of the Youth in Out-of-Home Care Project for Lambda Legal, thank you for joining us on the Imprint Weekly Podcast.
Thank you.
Thanks to Currey Cook, Director of the Youth and Out-of-Home Care Project for Lambda Legal, for joining us today. The Imprint Weekly Podcast is a production of the Safe Camp Audio Network, which is a division of Fostering Media Connections. Please visit safecampaudio.org on the web or at Safe Camp Audio on all major social media. This podcast is produced and mixed by Christine Anjoko with music by Luke Giroux and Cyrus Elia. If you enjoyed this episode, we would love it if you consider subscribing or giving us a 5-star rating on Apple, Spotify, or wherever you download your podcasts. And we would greatly appreciate if you consider supporting our work here on the podcast and in print. Small donations from our listeners and readers go a long way towards helping us grow and cover more great stories in child welfare and youth justice. To support us, very easy. Just go to imprintnews.org/donate. You can follow the Imprint on Twitter and Facebook by searching the handle @theimprintnews and visit our website at imprintnews.org. You can always reach us over email at tips@imprintnews.org. I'm John Kelly, and we'll see you next week.